Hello, John McConnin here. I'm an attorney and a real estate broker. I created forshortsales.com. I got motivated to get it out there faster by an email that went around yesterday regarding new case law. A realtor who does have, I subscribe because he puts out good information about lending and mortgages. Yesterday sent out an email saying that there was a new court ruling that allows deficiency judgments on purchase money loans. He cited an attorney. And I had an email exchange with him. I hadn't had a chance to look at the case yesterday, but now I have. And I've had realtors who contact us. We're negotiating some of their files, ask us about this case. And let me just say that before we begin, the facts of the case are that it is a piggyback refinancing 80-20, and that these are refinance loans, not purchase money loans, which is why the conclusions made in that email would be incorrect. And how do I know that? Well, you can read the facts. You can see it's all about 580D, and I'll go a little bit more into what this case really means in a second. But here's footnote 2. Section 580B, that's the non-recourse statute that creates non-recourse loans for seniors and juniors when the money goes into the purchase of the property, also called purchase money loans. Section 580B is inapplicable to the instant case because the loans at issue were not used as purchase money. Section 580B prohibits all deficiency judgments in specified real property transactions involving the provisions of purchase money, regardless of whether the creditors conducts a judicial or non-judicial foreclosure. 580D works with the one action rule, and it's basically the point when a lender forecloses, they waive their right, in a non-judicial manner, they waive their right to go after the deficiency. When I got out of law school in 91 and we were working with clients in upside down situations, what was called the doctrine of merger back then said, well, the good news is if Union Bank or B of A holds the first and the second and the first forecloses, the second can't go after you for the money because the rights of the first and the rights of the second are merged together. And the case law back then said that they were merged from the day, if they did it on the first day, then they couldn't get rid of that merger, even if they sold them off to other people. I blogged about this a while ago. It seemed that when this whole short sale, when the whole upside down market was changing again, I said the doctrine of merger might be called into question because I believe it was the 9th District had a case that said if they sold it off before foreclosing, then they could break that merger concept. 580D seems to be elaborated. This Cattle Rock case and another one, B of A, seems, well, B of A one might be a little different. This Cattle Rock case says that, yeah, it's true. If they got rid of the loan before they foreclosed, then that new person is sort of a bona fide owner of the junior loan, and after the first forecloses, they become a sold-out junior, and they could go after the borrower for the money. So if you've got refinance loans, if you're not in the non-recourse category, then you've got to watch out when you've got two loans by the same company. But anyone who worked with us or a lawyer knows the seconds can be sold out juniors anyway. So it was only rare people probably who spoke with lawyers who knew about the doctrine of merger that are really going to get affected by this case. If you got two non-recourse loans, you're fine. If you got, and you should use that to get leverage against the banks, which we do all the time in our short sales to get better deals and deals accepted. If you got a non-recourse second, if you got a recourse second, you got to watch out about how much information you give the banks, how many assets you have, because in the end, you're basically giving money to someone who might be able to come collect from you if they force a foreclosure by not accepting your second. Nothing new, except for those people who are well advised and understood about the doctrine of merger. John McConnin, forshortsales.com. Please post any questions about all this. I'd like to get this community going. Basic level, lots of information, and then maybe maybe we'll talk about my law firm doing short sale negotiation for you in the next few weeks, and some other things, maybe certifications. But I'd like to get the community going with lots of information from a lawyer and from experienced realtors right up there, so everyone can really know the go-to site for short sales. I'd like to create this, so I'll be happy to answer questions, and we will do webinars in the future. Thanks, John McConnin, forshortsales.com.